Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and in today's episode of Polity Primer, we are going to ponder upon a very important question that is in news recently, whether women in India have a right over their own body or not. The title of our today's discussion is Abortion Law in India and the 26-week dilemma. In this discussion, we are going to ponder upon the following points of discussion. We'll firstly see India's laws on abortion. We are also going to see, is it possible to terminate the pregnancy beyond 26 weeks in India? We are also going to see, has the court ever allowed such termination? We are also going to analyze the rights of an unborn child and the concept of fetal viability. Fetal viability, we are also going to see some of the way forwards in this regard, and in the end we are going to see a practice question for prelims examination and a practice question for your mains examination. So now let us proceed to understand the background or the context of our today's discussion. The background is, and this is a case law that has been recently decided by the Honorable Supreme Court of India. So what happened in this case was, let me explain you in very brief. There was a married woman and she was already having 2 kids. But coincidentally she got pregnant again and she didn't want the child due to various reasons. So she approached the registered center for termination of her pregnancy, but no center agreed to terminate her pregnancy, and that's why she approached the Honorable Supreme Court of India. So the judgment was firstly given by a 2 judges bench of the Supreme Court. So firstly, after analyzing her situation, the 2 judges bench of Supreme Court was in favor of termination of her pregnancy. But what happened when she went to the hospital for terminating her pregnancy, the medical board intervened, and the medical board said that the fetus is viable in nature, or there is this fetal viability. So the fetus was showing signs of birth in it, and it was able for the fetus to survive if the pregnancy was carried on for the full term. So after hearing the medical board's opinion, the 2 judges bench of the Supreme Court gave a split verdict. One judge said that no, we are not going to allow this pregnancy, though it is completely legal. But one judge was in favor of termination of her pregnancy. So what happened was, the case was referred to a larger 3 judges bench of the Supreme Court, headed by our Honorable Chief Justice of India, and this 3 judges bench of the Supreme Court finally decided that they are not going to allow her to terminate her 26-week-old pregnancy. So this brings us to the question that what is the law that is applicable in India on such cases or on the cases of abortion. So if I talk about the abortion as a concept in very simple terms, it means putting an end to a life, to a fetus. So abortion in simple terms mean that you are ending a unwanted pregnancy. And if I talk about India, until the 1960s, abortion was illegal in India, and not only it was illegal, it was also criminally punishable, and a woman could face 3 years of imprisonment and or a fine under section 312 of the Indian Penal Code. But what happened in the mid 1960s? The government took a U-turn on its stand. Many reasons were there. First was the population boom. Then the government was aware of this fact that this abortion cases were happening illegally. So the government took a U-turn on its stance and constituted the Shantila Shah Committee. And this Shantila Shah Committee recommended that abortion should be legalized in India on various grounds. Firstly, to give safe access to women for terminating their pregnancy. Secondly, to stop the people who are not authorized to conduct the abortions, and they were still doing so. So to stop these unauthorized persons for conducting an abortion and to legalize abortion in India, like in certain circumstances, the committee recommended that yes, it should be legalized in India. So the recommendations of this committee led to the birth of the Medical Termination of Pregnancy Bill in the Parliament, which later became the Medical Termination of the Pregnancy Act of 1971, and it came into force on 1st April 1972. So currently in India, medical termination of pregnancy is allowed, but you cannot do it illegally. If you'll do it illegally, you will be punishable under section 312 of the Indian Penal Code. So what is this section 312 of the Indian Penal Code talking about? It categorizes abortion into two parts. First is the illegal abortion, and then there is legal abortion. So what do we mean by illegal abortion? Illegal abortion happens in those cases where from somehow you found out the gender of the uh, fetus and now you want to terminate the pregnancy, or by some malicious intention or by some hidden intention you are voluntarily causing miscarriage of a woman who is quick with her child, then you will be punishable under section 312. And this provision is also aimed to reduce female feticide in India. So this is the case of illegal abortion, and voluntary causing miscarriage is not allowed under section 312 of the Indian Penal Code. So what is allowed? What is a legal abortion? So there are two circumstances. Firstly, you are acting in good faith. Good faith. And secondly, you are acting to save the woman's life. Save the woman's life. For example, there develops a complication in the pregnancy and there has to be a choice made between either saving the mother or saving the child. And in those cases, if you are willing to save the woman's life, then you will not be liable under section 312 of the Indian Penal Code. So, section 312 of the Indian Penal Code envisages both these conditions. It also talks about illegal abortion and it also talks about legal abortion. So, if I talk about the categorization of the gestation period under the Medical Termination of Pregnancy Act, it is as follows. So, previously we know that up to 12 weeks you required one doctor permission, but after the 2021 amendment, the breakup is as follows. So, up to 20 weeks, this 12 weeks has been increased to 20 weeks. You require the permission of one doctor. 20 to 24 weeks, you require the permission of two doctors. But this 24 weeks cases is relaxable in certain cases of women. So under section 3 clause B of the Medical Termination of Pregnancy rules, certain women can ask the termination of their pregnancy. For example, women who are victim of statutory rape, minor victims of statutory rape, women who are not physically or mentally able to understand what has happened to them. Then there are other cases as well in which the women can ask to terminate her 24-week unwanted pregnancy, and these women are exempted under this 20 to 24 weeks clause. After 24 weeks, like greater than 24 weeks, you require the permission of a medical board. And this medical board is constituted under section 3 subclause 2 capital C of the MTP Act. And the medical board opinion becomes very necessary if the pregnancy has exceeded or the gestation period has exceeded 24 weeks. And the medical board's opinion is somewhat or the other final in certain circumstances, though it can be challenged in the court. And the medical board analyzes that whether it is viable to continue the pregnancy or the termination can be allowed. And if I talk about the composition of the medical board under the Medical Termination of Pregnancy Act, it is given under section 3 clause 2 capital D of the MTP Act. And the medical board consists of number 1, a gynecologist, number 2, radiologist or radiologists and sonologists. Number 3, a pediatrician as well. Pediatrician. And number 4, all other members as the state government may appoint. all other members. So this is the composition of the medical board under section 3 clause 2 capital D of the Medical Termination of Pregnancy Act, and this is the breakup of the gestation period. So this brings us to another question of our today's discussion. Is termination of pregnancy permissible beyond 26 weeks? The case which we were discussing, the petitioner was pregnant for 26 weeks when she asked the Supreme Court to allow terminating her pregnancy. So the answer is no. This is not a general rule. Post the 2021 amendment to the Medical Termination of Pregnancy Act, pregnancy above the age of 24 weeks can be limited only on 2 grounds. So what are these grounds? Your ground number 1 is immediate threat to mother's life, and your ground number 2 is fetal abnormalities. So until and unless there is a existence of these 2 grounds, you cannot terminate a pregnancy after 24 weeks. And even after 24 weeks you are going for termination of pregnancy, then definitely you will have to take the permission of the medical board, as I have explained to you when I was discussing the breakup of gestation period under the Medical Termination of Pregnancy Act. So as a general rule, this is not allowed. You cannot terminate a 26-week-old pregnancy. But then this again brings us to another question that we are trying to find an answer to in our discussion today. That has the court ever allowed termination of pregnancy beyond 26 weeks? Yes, the court has allowed in several cases. But this is not a general rule. These cases are the exceptions. And what are these exceptions? When the women whose pregnancy has to be terminated is a victim of statutory rape. So you cannot ask the rape victim to continue with the pregnancy. If the woman is minor, like she is minor and she has been subject to rape, then also you cannot say that you should continue with the pregnancy. So in these certain important cases, the court has allowed to terminate the pregnancy. And what happened in September 2022? A bench led by Justice Chandrachud allowed abortion for an unmarried woman as well. So the court ended this discrimination between a married and an unmarried woman, and the court held that even unmarried women in India have a legal right to safe access to termination of pregnancy. So the court interpreted the term husband to include a partner, and hence brought the unmarried women into the ambit of Medical Termination of Pregnancy Act. The bench followed the principles of transformative constitutionalism that promotes and engenders societal change, and the bench opined that or observed that the law must remain cognizant of the fact that changes in society have ushered in significant changes in family structures. So the court said that just because you cannot discriminate a woman on her marital status, just because she is unmarried does not mean she will not have a right to access safe and legal abortion in India. So the court allowed even an unmarried woman to terminate her pregnancy in a judgment in September 2022. There are also instances in which a court has overruled even the opinion of medical board. So in the cases of minor rape victims or minor victims who are not mentally fit or victims of statutory rape, the court has even overruled medical board's opinion in those cases and said that no, if it is harming her physical, mental or financial health, then we cannot definitely ask her to continue the pregnancy. Right to make a reproductive choice is a fundamental right within the ambit of personal liberty. Personal liberty given to a woman under Article 21 of our Indian Constitution, and this has been held by our Honorable Supreme Court in the judgment of K.S. Puttaswamy versus Union of India. So there is a reproductive choice of women that is given under Article 21 of our Indian Constitution by virtue of this judgment. Now let us discuss rights of an unborn child and the concept of fetal viability. So what is this right of an unborn child, and do unborn children have a right in India? Yes, they do have. Section 13 of the Transfer of Property Act considers unborn children as a living person for the purposes of transfer of property to them. So it is not so that unborn children in India do not have any rights. They do have rights. They are considered as a living person. And even if they are not born alive in the cases of Section 13 of Transfer of Property Act, their legal heirs will get the interest in the transferred property. So it is a kind of vested interest. So definitely you are considering that child to be a human in nature. That is why you are giving succession rights as well. You are allowing transfer of property in favor of that child as well. But when we talk about abortion in India, then the rights of a woman must trump when it comes to abortion, and the need to balance out the rights of the unborn child must be there. And from this, we derive the concept of fetal viability. Like the Supreme Court said in this case, the child had already developed a heartbeat. The Supreme Court said that no, we have to make a balance between a reproductive choice of a woman and a right of an unborn child. So, if the pregnancy is continued for the full term and there are signs that the child will survive, there is no fetal abnormality noticed. The medical board is also of the opinion that the fetus is showing vital signs such as heartbeat. Then in those cases, the Supreme Court refuses an abortion, and generally also terminating pregnancy after 26 weeks is not a general rule. It is only in exceptional circumstances that it is allowed. While courts have read the MTP Act liberally, the test of fetal viability as a benchmark to allow abortion is new in India. So, this concept is very famous in the US jurisprudence, but it is comparatively very new to the Indian jurisprudence, and for the very first time, I guess, the Supreme Court has applied this concept in the ongoing case while refusing to allow her to terminate her 26-week pregnancy. So, the Supreme Court is always in the favor of balancing of rights of two individuals. Like the women's rights should also be balanced out, and there should also be a balance of the rights of an unborn child. So now let me explain to you that why is abortion law in India criticized? What is the lacuna that this MTP Act is facing? So if we talk about the abortion laws in India, it is important to recognize that the decision to terminate a pregnancy should be in the hands of pregnant women. On one hand, you are giving her reproductive rights under Article 21 of our Indian Constitution. On one hand, you are arguing that it is her body, her choice. On one hand, you are arguing that it is completely her choice whether to bear the baby or not to bear the baby. But what happens under the Medical Termination of Pregnancy Act after 20 weeks? Like if you exceed the period of 20 weeks, it completely depends on the doctor and not on the women. That means the doctor will decide whether it is viable to continue with the pregnancy or to terminate the pregnancy. In UK, what happens that even if there is a week left, the women can still say, I do not want this unwanted pregnancy. So why are you asking me to continue this? And no one can do anything. Neither the parliament can do anything, neither the judiciary can do anything. If she wants to terminate her baby, she can go ahead legally. But this is not the case in India. After 20 weeks, the opinion of the medical board comes into picture, and you require the opinion of two registered medical practitioners. So this is not an absolute right that is given in the hands of the women, and the right of reproduction, the right of having a choice is not enforced in a true sense in India. While this aspect is not challenged, like the women are not challenging this opinion of two registered medical practitioners after 26 weeks. But what happens is they are running to courts. Like at the end of time, they have to run to the courts, and they approach the High Courts and the Supreme Court through way of a writ petition, and this definitely shows us that there is a legislative gap in the Medical Termination of Pregnancy Act. So what can be the way forward? How can you balance like both the interest of a woman and a interest of an unborn child? So for doing this, you have to first make it clear that whether a fetus is a living being or not. So under some laws, you are recognizing the fetus as a living being, and under some laws you are arguing that okay, fetus is not a living being. For example, this was argued in this case only, that you cannot give importance to the right of unborn child. So firstly, you'll have to make it clear that a fetus, whether it is a living being for the purposes of Indian laws or not. Secondly, fill the legislative gaps in the MTP Act. The process should not be so stringent that it ultimately defeats the whole purpose. For example, in this case only, it was argued that if you are allowing 24 weeks unwanted pregnancy to be terminated in certain cases, then what about the mental health of the woman who does not want to continue with the pregnancy and is forced to continue with this pregnancy? So there is a huge legislative gap that is there in the Medical Termination of Pregnancy Act. It is somewhat stringent, like you require a opinion of 2 doctors after 20 weeks. If you exceed 20 weeks, you require a opinion of 2 doctors, and the provisions are also very strict. Avoid unnecessary delays. Sometimes what happens is, when a woman is 20 weeks pregnant, she approaches the medical board or she approaches the registered centers for termination of her pregnancy, but is being denied. Then what happens? She again has to approach to the courts by way of writ petition. And since the case is ongoing, it definitely takes time. The medical board takes time to form their opinion. So this is in turn very harmful to the mental health and the physical health of the pregnant woman. So this should not happen. The process should be very fast tracked, and the medical board should not take very much time in giving their opinion. It is important to ensure that abortion remains safe, legal, affordable, and accessible in a timely manner without causing additional hardship to the pregnant persons. So this is also very important, that you are safeguarding her physical and mental health. If she is not wanting to continue her pregnancy, you should allow it if it is for genuine reasons. So on one hand, it is being argued that women have reproductive choice, it's her body, her choice, and all those rhetorics. But ground reality is very different. It is completely not her body and not her choice. It is still dependent on many factors in India. So definitely the Medical Termination of Pregnancy Act needs a reform in this regard. So with this, we come to a conclusion of our today's discussion. We have seen that what is the recent fiasco about the 26-week dilemma. We have also seen what has the Supreme Court said in the case. We have also seen that is it in regular cases possible to terminate a 26-week pregnancy. We have also seen that whether the court has allowed it in previous cases or not, and we have also understood the lacunas in the Medical Termination of the Pregnancy Act. And we have also seen that the question which I asked you when I started the lecture, that do women in India have a reproductive choice in the true sense? Partially yes, but partially no. Up to 20 weeks it's her choice, but after 20 weeks the decision comes in the hands of the doctor and not of the women. So definitely you need to give her the free will to abort if she does not want to continue with her unwanted pregnancy. So now let us discuss a practice question for your prelims examination. So the question is, consider the following statements. So statement number 1 is, in India, the Medical Termination of Pregnancy Act is the governing law for abortions. Your statement number 2 is, the MTP Act was amended in 2021, extending the abortion limit from 20 to 24 weeks. Which of the following statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us discuss a practice question for your mains examination. So your question is, in the context of the Medical Termination of Pregnancy Amendment Act 2021, critically examine various issues in India's law on abortion. So firstly, you will explain that Medical Termination of Pregnancy Act. You will explain the gap of gestation period, like the breakup of gestation period, which I have discussed in my lecture today. Then also write the various lacunas, that there are legislative gaps. The medical board sometimes becomes very, the opinion becomes very delayed in nature. You'll also write that there is no absolute choice in the hands of the woman, and after 20 weeks, it completely depends on the doctor the doctor will decide whether the woman can continue with her pregnancy or cannot continue with her pregnancy. And you'll also write the provisions that have been added by the 2020 21 Act, and you will give a holistic conclusion to your answer that though the law is very good, but it needs some reforms, and there should be a free will on the woman whether she wants to continue with her pregnancy or she does not want to continue with her pregnancy. So you can conclude in a very holistic manner. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you found the today's discussion to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.